Hi, I'm Andrew Meinzer of Meinzer Law Firm PC. Today I'm going to continue to talk with you about capacity and incapacity. Specifically, we'll discuss some capacity rules that overlay all the rules discussed in the first and second videos. This is the third video of a three-part video series. In the first video, we discussed the lack of capacity for managing someone else's affairs through a conservatorship court proceeding or through her trust and powers of attorney. In the second video, we discussed the capacity necessary to sign trusts, wills, powers of attorney for financial management or asset management, and powers of attorney for healthcare or advanced healthcare directives. Overlaid on all this, California law also provides that there is a rebuttable presumption of capacity. And also overlaying all this, California states that a person lacks capacity if, 1, he or she is totally without understanding or is of unsound mind. 2, the deficit is substantial in mental function, not merely a diagnosis. And 3, there's a correlation between the deficits and the decision or act in question, such that the deficits significantly impair the person's ability to understand and appreciate the consequences of her actions with regard to the decision or act in question. A person does not lack capacity if she can communicate, appreciate, and understand the consequences of the decision in question and has none of the deficits. So I'm going to talk about the deficits that the court considers. I have them written down. I'm just going to read them off of paper. So the deficits that the court considers are alertness and attention, including level of arousal or consciousness, orientation to time, place, person, and situation, ability to attend and concentrate, information processing, including short and long-term memory, ability to understand and communicate, even if non-verbally, recognition of familiar objects and familiar persons, ability to understand and appreciate the following: quantities, rights, duties, responsibilities created by or affected by the decision or act, probable consequences for the decision maker and, if appropriate, the person affected by the decision or act, significant risks, benefits, and reasonable alternatives involved in the decision or act. Also consider the ability to reason using abstract concepts, the ability to plan, organize, and carry out actions in one's own rational self-interest, and the ability to reason logically. The court also considers thought processes, including severely disorganized thinking, hallucinations, delusions, uncontrollable, repetitive, or intrusive thoughts, mood and affect, including pervasive, persistent, or recurring euphoria, anger, anxiety, fear, panic, depression, hopelessness, despair, helplessness, apathy, and indifference. So those are the considerations that California courts take into account. A person's physical limitations also count when determining whether she lacks capacity. The primary reason is because communication is necessary to be able to conclude that a person has capacity based on most of the requirements and considerations that I just discussed. The communication does not need to be traditional verbal communication. The communication can be by eye blinking, hand squeezing, etc. When assessing a person's capacity through such non-traditional communication, you must be careful to be sure of clear communication. Making a mistake assessing a person's capacity regarding a conservatorship court proceeding and trust and estate plan documents could be catastrophic. If a person lacking capacity signs a trust or other estate plan documents, someone may be able to invalidate the trust or other documents when those documents are needed, and that would be through court litigation. Hiring an attorney experienced with conservatorship court proceedings and trusts can help avoid a lot of this. In addition, the advice and guidance of an attorney experienced with conservatorship court proceedings and trusts is invaluable for attaining your goals in these types of cases. At Meinzer Law Firm PC, we have over 20 years of experience helping clients achieve their goals in conservatorships and trust cases. Again, I'm Andrew Meinzer of Meinzer Law Firm PC. If you know that you need our help, or even if you just have a question, please contact us and let us take care of you.